Hello, welcome everyone to the Disability Federal Law Overview.
My name is Judith Spain. I'm with the Georgia Independent College Association, and I'm the Compliance Collaborative Program Consultant.
And I'm Jennifer Wilson Loggins, the Learning Center Director and Disability Service Provider for Brenau University.
Today we're going to be talking about the federal laws that deal with individuals with disabilities. Specifically, we're talking about the American with Disabilities Act, the American with Disabilities Act as amended in 2008, and Section 504 of the Rehabilitation Act of 1973. The American with Disabilities Act was the first comprehensive civil rights law to protect the rights and prevent discrimination against individuals with disabilities in employment, private, and community life. There are actually 5 separate titles under ADA, which address the areas of employment, public and private sector access, telecommunications, and miscellaneous areas, including retaliation and coercion. The American with Disabilities Act, as amended in 2008, revised the definition of a disability to more broadly encompass impairments that substantially limit a major life activity. Mitigating measures which are needed, including assistive devices, auxiliary aids, accommodations, medical therapies, and supplies, other than eyeglasses and contact lenses, have no bearing in determining whether a disability qualifies under the law. The ADAAA covers impairments that are episodic or in remission that substantially limit a major life activity when those impairments are active, such as a person who has epilepsy or post-traumatic stress disorder. The ADAAA contains crossover language contained in Title IX dealing with pregnancy with an accompanying medical condition. The Pregnancy Discrimination Act, it forbids discrimination based on pregnancy when it comes up to any aspect of employment, including hiring, firing pay, job assignments, other fringe benefits such as leave and health insurance, and any other term or condition of employment. So when you look at the Pregnancy Discrimination Act, Title VII, the Civil Rights Act of 1964, and Title IX, what we're required to do as a university is to treat all students, faculty, and staff affected by pregnancy, childbirth, or related medical conditions in the same manner as other individuals unable to work or participate in their education because of their physical condition. We may not deny employment or other educational opportunities based on the need to make a pregnancy-related reasonable accommodation, and we may not retaliate against individuals who request or use a pregnancy-related accommodation. Examples of employment accommodation or pregnancy-related accommodations could include things such as more frequent or longer break periods, more frequent restroom breaks, food or water breaks, acquisition or modification of equipment or of seating, job restructuring, or light duty if it's available. In front of you is the definition coming directly from Section 504. No otherwise qualified person with a disability in the United States shall, solely by reason of disability, be denied the benefits of, be excluded from participation in, or be subjected to discrimination under any program or activity receiving federal financial assistance. In other words, Section 504 specifically applies to Brenau University. It prohibits the denial of rights to participate in or have access to educational programs, and again, services in schools which receive federal financial assistance. With these changes now, both the American Disabilities Act as amended in 2008 and Section 504 are now consistent in their definitions and how access and accommodation is required. Again, clearly identifying that Section 504, ADA, and ADAAA all apply to Brenau University. Some of the goals of ADA, ADAAA, and Section 504. The United States of America has very clear goals in looking at what we're supposed to be doing. We're supposed to provide a clear and comprehensive mandate for the elimination of discrimination against persons with disabilities. Our goals regarding individuals with disability is to ensure that they have a quality of opportunity, that they have full participation, independent living, and economic self-sufficiency. More specifically, under Section 504, colleges and universities cannot establish rules and policies that may adversely affect a qualified student with a disability. They cannot make pre-admission inquiries as to whether or not an applicant has a disability. They cannot prohibit or harass a qualified student with disability from requesting or receiving reasonable accommodations for academic or physical modifications. They cannot limit or exclude eligibility to a qualified student with a disability from receiving financial assistance, either from scholarship, fellowships, or internships, solely on the basis of that student's disability. Under Section 504, colleges and universities can also not limit the number of students with disabilities admitted. They cannot exclude an otherwise qualified student with disability from any course of study. We cannot counsel a student with disability toward a more restrictive career. And we cannot measure student achievement using modes that adversely discriminate against a qualified student with a disability. So when we use the term a qualified individual with disability, what do we mean by the term disability? Well, there's actually three definitions of a person who could be deemed to be disabled. One is a person who has a physical or mental impairment which substantially limits one or more of that person's major life activity. A person could also be deemed to be disabled if they have a record of such impairment. And again, the impairment is defined as a physical or mental impairment which substantially limits one or more of the person's major life activities. Or third, if we regard the person as having such an impairment. And again, the same definition of impairment. In this particular situation, the person is actually not impaired, but we regard the individual as having a physical or mental impairment which substantially limits one or more of their major life activities. Therefore, under the ADA and ADAAA, they are deemed to be disabled and discrimination against them is prohibited. So who do we protect under these laws? We protect individuals who have a disability. Individuals who, with or without a reasonable accommodation, can perform the essential functions of the employment or college education or position that such an individual holds or desires. A person having an association with a person with disability, or a person acting as an advocate for a person with a disability. So again, all of these individuals, all of these qualifications, these three elements here, protect an individual from discrimination based upon their disability. Some disabilities are invisible. If you see a person in a wheelchair, that's a visible disability. But you're not going to be able to understand or be able to realize a person has dyslexia, or they have fibromyalgia, or they have ADHD. So some individuals, some disabilities are invisible. That does not mean the person does not have a disability. It simply is not visible to the eye. However, that individual still may need a reasonable accommodation. So whether the disability is visible or invisible, if the person needs a reasonable accommodation, we should do so in order to be in compliance with the law. So what do we mean by the term an otherwise qualified individual? If a student has a disability, whether they need a reasonable accommodation or not, in order for them to be deemed to be otherwise qualified, they must meet the college entrance criteria that allows them to be admitted into the college. If a student meets the entrance criteria for a specific program, then that student is considered otherwise qualified. So if a student has a disability and they need a reasonable accommodation or they do not, they still must meet the college entrance criteria to be admitted to Brenau University. And if there's a specific criteria for a specific program at Brenau University, they must also meet that as well. Colleges and universities must provide equally effective alternate access to electronic and information technology for students with disabilities. Effective alternate access is determined based upon timeliness of delivery, accuracy of translation, and delivery in a manner or medium appropriate to the disability of that particular student. Colleges and universities must ensure that any new technology which is being made available to students must be accessible to all students. If the new technology is commercially available and its purpose does not result in undue financial or administrative burden or a fundamental alteration of an academic program, we must ensure that that technology is accessible to students with a disability and students who do not have a disability. So when we look at instructional materials or online courses, we need to remember that those materials and courses need to be fully accessible to individuals with disability, as also all students who do not have a disability enrolled in the same class or in the same program. If you have any questions about ADA law, please make sure that you connect with Jennifer Wilson Loggins, the Brenau University Learning Center Director, as well as a disability service provider. Thank you for your attention.